All right, thanks so much for that, Rachel. I want to bring in Michel Bryant, attorney Michel Bryant. Thanks for joining us.
Pleasure. Good to see you, Vincent.
So you've been following this trial, this cover-up trial. My question is, how do you prove a cover-up?
Well, let me tell you, it's not easy, first of all. You know, you've got to prove the underlying problem, that there was knowledge of whatever those acts were that were criminal. And then you've got to prove the secondary acts, which were what was done in furtherance to hide the underlying crime. And in this case, you know, this case is so email intensive. I don't know if you've had a chance to look at it. There are hundreds of emails. Right. Hundreds. And they are increasingly incriminating in terms of trying to prove a cover-up, because there's some calculating going on about what should be told to the press, what should be discussed, what will be released. Remember, it was more than a year before the video was even released.
Exactly.
Now, I happen to have one of these emails. Very helpful, isn't it? Look at this email. This is, you know, what are you going to do with this?
Yeah, what do you do with that?
So much of this is redacted. I don't care what's under here.
Right.
It looks bad.
But, Michael, you brought up a good point. You said the word hide. Now, we heard March's attorney say, listen, he actually logged in the dash cam video. He logged in other video from surrounding businesses. He logged in all the shell casings. So what is he trying to hide here?
Well, you know, it sounds like he's giving you everything you're looking for, right?
Right.
But the overall, and there was some missing video too. We understand there was some video that just for some reason never surfaced. But all you need is the one video everybody has seen to make it clear that the cops were kind of making things up. They didn't roll out as the cops suggest. There was no overt act by the ultimate decedent against these cops. There was, if anything, he was paralleling their motions and then was shot 16 times.
Yeah, I think the key to this whole case will be the video. I think that's the biggest piece of evidence in this trial right here, the video, because it doesn't match what we've now seen in those reports.
Of course, and there's a good reason that the judge is dealing with this case. It's not a jury trial. Right. You want to take the emotion out of it. You've still got to convince the judge, now as the trier of fact as well as the legal expert, that these things happened in the way the cops said they did, not as the video portrays it, and that the cover-up was somehow innocent, that they weren't in cahoots to cover up what their fellow cops did.
Right. Now, we heard testimony from a Chicago police officer, Officer Fontaine, in this case, and she said, hey, what they said in the report doesn't match what I saw. There was also another retired detective from Chicago that took the stand in this case. Let's take a listen. Hey, welcome back to the Law and Crime Network. We're still waiting closing arguments in the Chicago cop cover-up trial. We're expecting that here in about 10 minutes. As soon as we have a live feed in that courtroom, of course, we'll go right there. But just before the break, my guest Michael mentioned some emails. Let's hear the defense's argument to keep those emails from being admitted into this trial.
Been able to even put Joe Walsh in the same room as these two other individuals, much less Jason Van Dyke, who they referred to in the indictment as individual A. They haven't presented evidence of a phone call between Joe Walsh and any of these other alleged conspirators on the night of this event. A text message.
All right, I apologize for that. It appears that clip is having a few technical difficulties, but that's all right. It's live TV. You never know what can happen. Michael, we talked about these emails, but how crucial, we know that they got admitted. We know we're waiting for closing arguments in that case, but how crucial are these emails? Because there were certain phrases, certain terms in those emails. But here's the thing. The emails came out before the video. And one thing I always tell people when dealing with police matters, wait until you have all the evidence. So I guess we need to say that for cops as well, right?
Good idea.
Wait till you have all the evidence.
And maybe they thought the video was somehow never going to come out because they dug a deeper hole with this series of emails, which was creating a very different picture than the actual video picture. And I think it made things even worse for the authorities, because when the video came out, you had a series of emails that contradicted what the video showed us. Now, we've got a lot of charges in this case. The conspiracy charge, I think, is the weakest, because there has to be some sort of concerted effort between the parties to come to this cover-up. That doesn't mean each and every one of them can't be guilty of obstruction of justice, as an insular crime. So it's not like, hey, we get out of conspiracy, we're free and clear. That's not going to happen.
Yeah, but the thing is, with these emails, they weren't from any of the officers involved in the case. They were other officers that were sending these emails. So to your point, how do you prove this conspiracy? Because they weren't emailing each other and saying, hey, you say this, I say this. It was other officers.
Exactly. And I do know that there are folks involved in this case who say there are probably 5 or 6 others that should be sitting at the defense table right now, but they're not. Maybe sometime down the road they will be. But you're right. It's one connection removed from the actual defendants in this case. So it's much harder to tie them to the wrongdoing that we see laid out in these emails.
Right. Do we have that clip back up? Not yet? All righty. So we're still waiting for that clip to play. But again, we're still waiting on that courtroom to go back live in Chicago. Chicago cover-up trial. 3 Chicago police officers, well, 2 former Chicago police officers, 1 current, are on trial right now for an alleged cover-up in the shooting death of Laquan McDonald. He was shot back in 2014 16 times by Jason Van Dyke, who was convicted of second-degree murder just a couple of weeks ago, and 16 counts of aggravated assault. We saw a lot of testimony during that trial. Michael, let me ask this. One of the things I found interesting here, me being former law enforcement, you don't see this a lot. You actually saw Officer Fontaine taking the stand, raising her hand, giving an oath, and saying, hey, that's not what happened.
Yeah.
So now she's labeled as this huge rat in her department. You know, so she essentially put her career and her livelihood on the line.
She crossed the blue line, you know. I mean, they had a pretty united front in this case. Again, I think naively thinking that nobody would believe their own eyes when they saw the video. But somehow she felt she had to do the right thing. And you're right, she's probably going to have a problem working in that department, in that community, maybe in law enforcement as a whole.
Well, I understand she was reassigned to desk duty, you know, taken off the street, which is pretty wise, because if you don't have backup out on the street, trust me, I know, yeah. I did that job for 5 years. If you don't have backup, you are in a lot of trouble out there on the street.
And even on a desk job, it's going to be miserable.
Oh, yeah, it's definitely going to be miserable for her, because nobody even wants to talk to her at this point,
yeah.
Right? Nobody wants to talk to her. So Jason Van Dyke, when he shot Laquan McDonald, his statement was, oh, he was advancing towards me, right? We saw the dash cam footage. We know that's not what happened. So do you even think Fontaine's testimony was even needed at that point?
Well, you know, I think maybe it was more important from a philosophical standpoint, where you could actually show one of the police officers crossing that blue line to reinforce what the video showed. You're right. Maybe you don't need to hear somebody say that, but how important was it just to show that she was able to, on her own, corroborate what the video said, regardless of what the impact might be to her professionally? That was very brave.
Yeah, it was very brave. What do you think the chances are for the prosecution in this cover-up trial?
Well, you know, I think this is so different than the other trial, primarily because it's a bench trial. Mm-hmm. And you know, we don't know enough about the judge and his proclivities, and it's a female judge, isn't it?
It is.
Yes, okay. Dominica, as I recall.
Yes.
Yeah, I just think that's the wild card, because remember, the judge is figuring out everything, the law and the facts, and I think there's enough here to find guilt on at least the obstruction charge.
All right, I think we are ready to roll that clip. Let's take a look. All right, that was the prosecution in this case talking about those emails and getting those admitted. Michael, I want to read something he said here. It said that they were working to assist the fellow officers during an active investigation. Therefore, it's a conspiracy and a cover-up. But I don't see it that way. I mean, when you have a police shooting or something like that, again, I've done this job. The FOP comes to talk to you. You know, there may be a police union that comes to talk to you. So how, just by these officers sending these emails, are they conspiring to cover something up?
You know, to have the conspiracy, you have to have a meeting of the minds,
mm-hmm.
right? So I think what he's suggesting is that their actions in and of themselves created, almost implied, a meeting of the minds, because they were doing these reports that they might normally do,
right?
But that it somehow implies that they got together and created some sort of consistency in their reports, even though those were done by individuals. Mm-hmm. And there's no direct evidence that they got together and had a beer and said,
right.
Hey, what are you going to put in your report? I'm going to do this.
Right.
I think that's what he's trying to do, is just plant that seed, that you can have a meeting of the minds without some more direct, formal connection.
Yeah, got it. Now, in fairness, though, you know, police, again, use certain phrases and words. That's how they're taught. That's what they're told to write on reports based on the use of force continuum. So, you know, maybe the prosecution's onto something. That's up for the judge to decide. Again, this is a bench trial in Chicago. We're still waiting for that trial to go back live. We're going to take a quick break. We have so much more to come. We have Chicago. We have Wisconsin. There's a lot going on here today on the Law and Crime Network. Stay tuned. We'll be right back. Okay, we're watching closing arguments from the prosecutor in the Chicago cover-up case. One question for you, Michael. Now, I've done police reports in my 5+ years of policing. Sometimes you check the wrong box.
No.
I'm playing devil's advocate because I've done it myself. I've checked the wrong box, not intentionally, but it's a mistake. And typically I have to do a supplement report to correct it or something. Could it be, playing devil's advocate, that on that TRR, this was a mistake?
I mean, it's possible, obviously, but if you're Patricia Holmes, the prosecutor in this case, you're making it look like this was no mistake. This was intentional. These folks who filled out these TRRs totally separate from one another, with totally separate experiences that night, checked the same box referencing the deadly force element that would have justified the shooting of this young man. Yeah, it's pretty good argument.
Yeah, it is a good argument, but again, playing devil's advocate, it could be a mistake, and maybe, just maybe, that the other officers were going on information they were told.
That's right, and the judge gets to sort that all out.
That's right. We still don't have quite a cover-up. We're going to be right back to that closing arguments in the Chicago cover-up right on the other side of this break. Stay tuned to the Law and Crime Network. All right, the prosecution, as you can see, is still giving closing arguments here in the Chicago cover-up trial. Still with me, Michel Bryant. Michael, I want to point out something she said here. And again, I just want to play devil's advocate, and I hope the producers can get the B-roll up of Laquan McDonald walking down the street. She mentioned that they put in their reports, you can see there on your screen, he was swinging the knife. And I think maybe right there you can see it's just kind of more, it's swinging. So I guess in a sense they were being truthful in that statement that he was swinging. But is it more of it was swinging because that was just his natural sway of his body? Or was it in a defensive manner, as these defendants have said?
If you just read the report, it suggests it was much more aggressive. Mm-hmm. You know, I'm swinging the knife, as opposed to I'm walking down the street and, by the way, my arm is swinging, so hey, the knife is swinging, which is the reality we see in the video.
Yeah, absolutely. I think personally it goes back to that was just the natural swing of his stride.
Yep.
But we heard Van Dyke during his testimony, again, he was convicted of second-degree murder, that even at one point Laquan raised the knife and he could see it over his left shoulder.
Right.
We don't see that here.
Nothing even close to that. So yeah, Van Dyke was hanging it out there, and he got caught.
Yeah.
And that was just so far from what we saw in the video. It was just unbelievable.
Yeah, absolutely. Of course, we don't know what's going to happen in this trial. Of course, it's a bench trial. But how good of a chance do you think the prosecution has to making some of these stick? Now, if they lied in their reports, as the allegation claims, of course, there is official misconduct. But the conspiracy part, do you think they have a case here?
You know, I think you've got to believe that these officers, when they put these reports together, and we just heard the prosecutor reference some sort of meeting in a room with a lot of the players here. Nobody knows what was being said. She's trying to imply that, hey, these reports didn't get identical by accident. You know, these guys, officially, unofficially, directly, indirectly, came to some agreement as to what these reports should include, even to the point that a couple of the officers who would not normally have filled out those reports did so. Well, why would they do that, Judge? They would do that just to support the other reports. And if they're all doing that in concert, guess what? That's a conspiracy.
All right. Now, clearly, these charges are definitely not as serious as Van Dyke's. We definitely want to talk about that on the other side. We're going to have more of this closing arguments right on the other side of this break. Stay tuned to the Law and Crime Network. Okay, the prosecution just wrapped in that case. Michael, I want to talk to you about this sentencing. Of course, again, it's not as serious as Jason Van Dyke, obviously. But what kind of jail time could we be looking at here?
You know, it's funny when you think of the individual offenses, potentially, misconduct and obstruction of justice. I would think, my gut would say misconduct is probably not as bad as the obstruction. But I'd be wrong. because it's up to 5 years for misconduct, up to 3 years for obstruction.
5 years for misconduct.
Yeah, so that's a total of max of 8 years for those two offenses, plus up to $50,000 in fines. And if you are found guilty of the conspiracy, you can effectively double those numbers because the conspiracy relates to the underlying crime.
So essentially 16
years and $100,000.
And $100,000.
Yeah.
Wow, wow. Looks like the defense is giving closing arguments. Let's go to court right now. All right, that is the defense closing arguments in this cop cover-up trial. Still with me, Michel Bryant. Michael, he said this thing a few times during this trial, one line, and he's adamant that his client, David March, is not guilty. And he said we shouldn't even believe this other officer who was brave enough to actually take the stand and go against her other officers to say, hey, that's not what I said.
And he said it loudly, Vincent. He said it very loudly.
Very loud.
So it must be true. I mean, you know, he's got the theory that if I say it enough, loud enough, with enough conviction, maybe I can sway you a little bit.
Well, that's what he said the prosecution is doing. He said, well, if she says this was a false report enough times,
yes,
you will believe it.
Yes. And now he's using a similar approach here to get the judge to side with him. It's not unusual. He's just one of these guys that seems to pound a lot harder on the table than others do.
Very graphic, very in your face, very animated.
Yes.
But that works sometimes.
It can. It really can. But the underlying information, remember, this is a judge trial. Bench trial, not easily swayed like jurors might be. So yes, it's nice to be animated. It's nice to be adamant, physically gesticulating and making your point. But the judge can see through a lot of that.
That's right, and this is a judge who's seen a lot of this. I'm sure this judge was an attorney at one point, so she knows the routine.
She knows the game, yes.
Yeah, she definitely knows the game. Michael, thanks so much for joining us.
Pleasure.
We appreciate it. Always good to see you.
Nice to see you, Vincent.
We're going to take a quick break. We have so much more to come. It's actually almost time for the Daily Debrief. When we come back, Aaron Keller will be here with the Daily Debrief. He has a lot to cover. Chicago, of course, Len Kachinsky in Wisconsin. There's a lot going on here at the Law and Crime Network. I will be signing off. I will see you next week. Thank you so much. We'll be right back to the Law and Crime Network for the Daily Debrief. Stay tuned.